California's landmark rent control case highlights rental property owners' responsibilities. In the year 2019, Governor Gavin Newsom took measures to protect renters in California from exorbitant rent increases and unjust evictions. After almost 4 years, the state has finally taken its first action to enforce the California rent control law. On Wednesday, June 14, Attorney General Rob Bonta made an announcement regarding the San Jose-based developer and property manager, Valley Corp. This company will be held accountable for raising the rent of 20 Silicon Valley tenants by an average of 151%, which greatly exceeds the legal limit set by the law. Furthermore, the settlement reveals that the company unlawfully evicted 6 tenants without providing a valid reason, which is another violation. According to the terms outlined in the settlement filed at Santa Clara County Superior Court, Green Valley, also known as Swenson Builders, will be compelled to pay a total of $391,130. Out of this amount, $331,130 will be refunded to tenants as compensation for the excessive rent they paid. The settlement brings an end to the Attorney General's office investigation, which lasted for a year and a half. Last year, San Jose Spotlight reported that Swenson Builders raised the rent for nearly 24 tenants residing near San Jose, Japantown. Some of these tenants sought assistance from local legal aid organizations, which then reported the issue to the state's Department of Justice. The company reimbursed 3 tenants and acknowledged in a letter that the rent increases had exceeded the legally permitted limit. Since its implementation, tenant rights groups have criticized the 2019 law, claiming it lacks effectiveness. However, the recent enforcement action by Attorney General Bonta signifies a strong stance on behalf of the state. The 2019 law, introduced by Chiu and co-authored by the former Assemblymember Bonta, established an annual cap for rent increases at 5% plus inflation. Additionally, landlords are required to present a valid reason, known as just cause, before evicting a tenant without providing any compensation. Acceptable justifications include non-payment of rent, violation of lease terms, or engagement in criminal activities on the rental property. State law imposes strict limitations on how cities can implement new rent regulation policies or expand existing ones. The statewide cap imposed in 2019 was a significant departure from the long-standing resistance to any form of rent control. However, the law did not specify the entity responsible for holding non-compliant landlords accountable. Consequently, tenants, often lacking financial resources and legal representation, were left with the burden of challenging violations in court. Over the years, the maximum allowable rent permitted by the law has increased significantly across California. When the law was first enacted, inflation stood below 2%, resulting in a cap of approximately 7%. However, inflation has surged since then. In certain regions of the state, landlords have been legally allowed to raise rents up to the maximum limit of 10% in the past 2 years. Earlier this year, Senator Maria Elena Durazo from Los Angeles introduced a bill to strengthen the 2019 rent cap law. Although an initial version of the bill was modified to remove provisions that would have lowered the rent cap to 5%, the current version still includes measures to provide financial compensation to tenants who take legal action against their landlords. Furthermore, it explicitly grants local and state prosecutors the authority to initiate legal proceedings on behalf of tenants. Durazo's bill passed the Senate last month and is now awaiting review and deliberation in the Assembly. Notably, the apartment associations throughout the state vehemently oppose this bill.